A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. For this Monday, October the 10th, my name is Cam Edwards. So glad that you're with us on the program today. We got another busy week in terms of our right to keep and bear arms. We're watching the Second Circuit Court of Appeals. Last week, a federal judge in Syracuse, New York, granted a temporary restraining order blocking many parts of New York's Concealed Carry Improvement Act from remaining in effect, but he did allow the state of New York 3 days to appeal that decision to the Second Circuit. The state of New York has announced its intent to do just that, although the official appeal has not yet been filed, at least as I'm recording. But I do anticipate that it will be coming within that 3-day window. I don't think New York is going to let a paperwork error allow for their laws to be unenforced for the time being. So we're watching the Second Circuit this week. We're also watching another courtroom, this one 3,000 miles away or so from Syracuse, New York, where Santa Clara County Sheriff Laurie Smith is facing a civil trial regarding allegations of corruption and graft when it came to the issuing of concealed carry licenses in Santa Clara County, which is in the Bay Area, not far from San Jose, San Francisco, and it's a part of the state where it's been traditionally nearly impossible for the average citizen to obtain a concealed carry license. The allegations are that in Santa Clara County, if you knew the sheriff, or perhaps if you were willing and able to donate sizable figures to a reelection fund, well, you could get your concealed carry license. Not only is Sheriff Laurie Smith facing this civil trial, but a couple of her top deputies are facing criminal charges for these allegations. And the trial officially began last week. I got to tell you, I started out my reporting career in Oklahoma City, Oklahoma. And my first beat as a reporter were cops and courts, and then eventually public schools, but cops and courts. And so I got to tell you, I have not wanted to sit through a trial. Sitting through trials can be really boring. But it has been a long time since I have thought to myself, boy, I would love to just be in this entire courtroom for the whole hearing. Unfortunately, given that this is 3,000 miles away from where I live, it's not possible for me to cover the trial in person. But there's been a lot of revealing information that has already come out. This trial is expected to last until November, so we still have a ways to go. But during the first week of testimony, we heard some pretty damning evidence, including one individual who is a tech titan in Silicon Valley, describe his experience in getting a concealed carry permit. Chris Malachowski, who is the founder of NVIDIA, testified a week ago that when he filled out an application in 2014, he just left the good cause requirement blank. So under California law, right, you're not supposed to get a concealed carry license unless you can demonstrate some sort of justifiable need or a good cause to carry, right? Somebody's threatening me. I have a lot of cash on me at night as I'm making deposits. Your right of self-defense wasn't seen as good enough in Santa Clara County, actually in the state of California, although there were some county sheriffs, and there continue to be county sheriffs who have always said, yeah, you know what, your right of self-defense, that's a good enough cause for me. That wasn't the case in Santa Clara County. And so Chris Malachowski doesn't fill out the section of his application requiring him to show good cause, and it didn't matter. It didn't matter because he still received his license. Meanwhile, there were two criminal defense attorneys who had no ties or support of Sheriff Smith, who reported serious and violent threats that were made to their lives. They testified about applying for concealed carry permits in the last decade. They described getting the runaround from the Santa Clara County Sheriff's Office, being sent a form response, citing the excuse of a huge application backlog, or getting no response, despite multiple attempts at follow-up. Sometimes they experienced all three. Malachowski, meanwhile, who is a donor, yeah, he gets his concealed carry license, no questions asked, In fact, not even having to fill out the entire form. But meanwhile, you've got these defense attorneys who are saying, listen, we've got threats being made against our life. I would really like to be able to carry a firearm for self-defense. And if they hear back from the sheriff's office, it's just, again, that standard form. Well, we're processing your application as quickly as we can, but we got a huge backlog. There were no backlogs in Santa Clara County because there were very few applications overall because most people knew that they were going to be denied. Now, we've also heard previously that in many cases, when Sheriff Smith or her deputies didn't want to approve a permit, they just kind of tucked it in a drawer and left the application there. Sometimes they wouldn't even communicate to the applicant that they had been denied because they were just left in limbo. Now, one of the defense attorneys who testified at trial last week said that she applied for a third time last year, only to once again be stonewalled. She said that the violent threat that she faces from a former spouse, quote, continues today. And while she's being denied, Malachowski testified he never actually carried once he had his permit, and he let it lapse because he, quote, didn't like the responsibility of it. Unbelievable. As the East Bay Times reports, Malachowski's testimony shielded from criminal prosecution under a grant of immunity from the San Mateo County Superior Court Judge Nancy Feynman. She's presiding over Smith's trial. The San Francisco DA's office is prosecuting because of various conflicts declared by the local court and in Santa Clara County. One of the other key witnesses this past week was an individual who is also facing criminal charges, but he testified under a grant of immunity in this civil trial. His name is Harpreet Chadha, and he donated a luxury box at the arena where the San Jose Sharks play. Donated the use of that luxury suite to the sheriff's office. Sheriff Smith and a group of friends and supporters actually used it to celebrate her re-election win in 2018. And again, he has been described in a separate criminal indictment as doing so, in essence, as a bribe in order to speed up the renewal of his concealed carry license. Now, he has said that's not the case. Says that he routinely gave away access to that suite to local law enforcement officers and groups. And it said again, this isn't evidence of any sort of misdeed or wrongdoing, much less bribery on his part. However, according to testimony, prosecutors in both the criminal and civil cases have drawn attention to the fact that Chadha's secretary in the sheriff's office had gone back and forth for 2 years over the renewal of his permit, which emails described as being perpetually on hold, which is something that we had talked about just a couple minutes ago, right? You don't want to approve it, you just keep it on hold forevermore. And it was formally issued to him. It finally, started moving 2 days before the February 14th, 2019 Sharks game that Smith and her supporters attended. Yeah. He says donations of the suite were often done to fill out unused game and event dates that weren't occupied by his business clients and family, and he reaffirmed that stance on the stand. He says it was a very big burden off of me, saying that he generally preferred to see the suite used rather than let it go to waste. Fine, that's understandable. However, as the East Bay Times points out, other testimony like that of the former executive assistant to Chadha, Kim Borland, suggested that Chadha did get preferential treatment, including not having to complete a required firearms proficiency exam at the sheriff's gun range. Yeah. So again, it sure seems like if you were a donor to Sheriff Smith's re-election campaigns, you stood a better chance. I won't say it was a guarantee that you got your permit, but you stood a much better chance, it seems, of getting one. And even at a time in which applicants with a clear need to carry in self-defense, forget about the fact that it's their right. Under the previous rules in California, they had demonstrated good cause to carry. And they were still, again, left in this legal limbo. Maybe because they weren't ponying up the cash to get the sheriff reelected. Now, this is a civil trial. As I mentioned, Sheriff Smith's top deputies are facing criminal charges. Smith is facing a civil trial. If she is convicted at civil trial, she would have to leave office. What's interesting is that Sheriff Smith already said she's not running for re-election. She is resigning, in essence, I think in early January. I think that's when the next sheriff will take over. So this is a matter of, at best, forcing Smith out of office a few weeks before she leaves. Now, the criminal charges against her underlings, those remain intact as well. And hopefully those cases will proceed even further. I'd like to think that this is a moot point. Now that the Supreme Court has struck down these good cause requirements, I'd like to think that this is something we don't have to deal with anymore. Unfortunately, I don't think that's the case. We've already seen in New York attempts to establish new subjective standards, right? Well, we got to make sure you are of a good moral character, right? In Massachusetts, they're using that same sort of language to once again use arbitrary and subjective standards to approve or deny concealed carry licenses. And I suspect that in some California counties, that is going to be the case as well. We saw the anti-gunners have a bit of a hang-up in California. They wanted to pass emergency legislation that would have enacted all kinds of sweeping new restrictions on the right to carry in California, which is already pretty restricted, by the way. But there was some internal politicking that led to the defeat of that bill in the California legislature. So they're going to bring it back here in a couple of months. And I do expect, again, that we are going to see Democrats in California abuse and ignore the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin, again, in order to prevent as many people as possible from exercising the right to carry. And one of the ways that they'll do that, again, is through the use of arbitrary standards whenever and wherever they can get away with it. As we've seen, not only in Santa Clara County, as we've seen in New York City, as we've seen in other California jurisdictions and other major issue jurisdictions around the country, this arbitrary and subjective authority that can be used to deny people their Second Amendment rights opens the door for graft and corruption. It enables graft and corruption and doesn't excuse any graft or corruption committed on the part of law enforcement officers, but we can make sure that they don't have the opportunity to indulge in these types of crimes by foreclosing that possibility and mandating that if applicants meet the statutory requirements, they meet the training requirements, they pass a background check, they get their concealed carry license. When you remove that discretion from county sheriffs, you also remove the opportunity for the type of graft and corruption that is alleged in Santa Clara County. And it is long past time that the state of California and every other may-issue jurisdiction out there do this. Not just because we want to make sure that we don't have graft and bribery taking place in our law enforcement agencies, but again, fundamentally, because these laws are depriving tens of millions of Americans of their constitutional right to keep and bear arms. Now, let's turn our attention to today's arms set. We, by the way, will keep following the trial of Sheriff Laurie Smith there in Santa Clara County, California, and we will update you at Bearing Arms as best we can until this trial concludes and a verdict has been reached. All right, now let's turn our attention to today's Armed Citizen story, our good deed of the day, and our recidivist report. We'll start there. It's not a recidivist report per se. I don't believe this individual has any previous crimes, but it is a sentence that has left me scratching my head anyway. A Jefferson City, Missouri man sentenced to probation for shooting at a vehicle with somebody inside, by the way. 18-year-old DeAndre Hughes pleaded guilty to a charge of second-degree assault, which is a felony, in Jefferson City last week, and was sentenced to 5 years of supervised probation. Jefferson City Police Department says that officers were called back out on March the 6th for a report of shots fired. DeAndre Hughes was reportedly attempting to fight another individual after being driven to the area. The victim in that case was in another vehicle that was leaving. And as that vehicle was pulling away, authorities said Hughes stood on the roadway, took out a gun, and fired several shots, reportedly intending to hurt the victim. The victim and the vehicle were not struck, but the intent was there. So why on earth is DeAndre Hughes walking away with probation after this? Investigators interviewed the person who drove Hughes to the shooting. He said that she had driven her there because a fight was supposed to take place. She said Hughes tried to fight the victim and confirmed that when the victim drove away, Hughes produced a handgun, fired several rounds. I don't get it. I don't get it. I know it was a first offense. I know the, supervised probation theoretically means that young Mr. Hughes is going to have eyes on him over the next few years. And if he commits another crime, then he could be sentenced to prison for this original offense. I know all that. I also know how unlikely it is that those things are going to happen, because we have seen time and time again that even when someone on probation is arrested and charged with an additional crime, not always do we see probation revoked. Or if we do, they're put in jail for a couple of months as opposed to, fulfilling the original sentence. Again, I'm just puzzled by this. Seems to me like if you want to cut down on juveniles and young adults committing violent offenses, I don't know, maybe you provide some consequences when they were arrested, charged, convicted, or plead guilty to those violent offenses. Meanwhile, in Pennsylvania, today's armed citizen story, Bucks County, where police say a shooter acted in self-defense in a incident in which 2 people were killed, another was injured outside of a bar over the weekend. This was, again, originally described as a triple shooting, but police say that the shooter in this case not expected to face any charges. This was about 11:30 Friday night. Police responded to several calls for a shooting in the parking lot of the Steam Pub in Upper Southampton, Pennsylvania. One of the people who called was the individual who fired those shots. He was there on scene when police arrived. He cooperated with officers there. 2 men were found dead when officers arrived. A third victim, a third individual, a 24-year-old man, also struck in the shooting, but suffered non-life-threatening injuries. 30-year-old Stephen Panabiak of Bensalem, Pennsylvania, 28-year-old Raymond Farrell of Philadelphia were the 2 individuals who were killed. Upper Southampton Police Chief Dominic Vericello told Fox 29 in Philadelphia during the investigation it was shown that the 21-year-old shooter, who is a licensed concealed carry holder, acted in self-defense. And police say at this point they do not expect any charges to be filed against that 21-year-old, who, by the way, one of the conversations we've been having quite a bit lately is how old do you have to be to exercise your Second Amendment rights? I don't see any reason why this 21-year-old should not have been able to exercise his right to bear arms in self-defense when he was 20. But we hear all the time, right, that young adults just aren't responsible enough to handle their Second Amendment rights. Well, here's a 21-year-old who apparently did have the presence of mind to act in lawful self-defense against multiple attackers on Friday night. We'll keep our eyes on this story as well, bring any details as they become available. Finally today, our good deed of the day out in California, where a woman in Vacaville, California, is safe today after she was attacked on a bike trail. Saved, this woman was, by a crew of inmates and an officer who was supervising that crew of inmates as they were doing like trash pickup, I guess, on a trail. It's crazy. Joe Baptista is a resident of Vacaville, and he says generally the trail's pretty peaceful. He says it's actually very, very rare for someone to be attacked on this walk. Well, rare or not, it happened. It was last Tuesday, a 33-year-old woman was walking her dog when she was stabbed by an 18-year-old assailant. According to police, 18-year-old DeMarco Ross Parker stabbed the woman as this cleanup crew from the California Department of Corrections and Rehabilitation were nearby. They saw what happened, and both the officer overseeing that cleanup crew and the crew itself ended up taking down the suspect, not only helping the woman and waiting for police to arrive, but the crew detained Parker, who was then restrained with handcuffs belonging to the corrections officer. Officers now apparently are boosting patrol along the bike trail there in Vacaville, but I would hope that, again, incidents like this would reinforce your ability to be able to protect yourself, right? Vacaville, I believe, is one of those parts of the state where, generally speaking, it is not too hard to get a concealed carry license. And hopefully it'll be even easier now for law-abiding citizens to do so, because you can't always expect that there's going to be a law enforcement officer or even a corrections officer and a cleanup crew around when you are the victim of a violent crime. Chances are the only person who's going to be able to put a stop to that attack is you. Now, that's going to do it for this edition of Bearing Arms, Cam and Company. I do appreciate you being a part of the program today, as always. I would also encourage you to head over to bearingarms.com throughout the day. As I said, we've got a lot of stuff going on this week. We're going to keep you updated on each and every item that impacts your right to keep and bear arms. Updating the website constantly throughout the day. If you like what you see, I'd also encourage you to become a VIP member. All you have to do is go to bearingarms.com/subscribe. Use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. As our way of saying thanks for showing your support, we're going to give you exclusive content, news stories, and analysis you won't find anywhere else, because your support does make a difference, and it really does matter. So thank you very much again. We'll be back here tomorrow. Until then, enjoy the rest of your Monday as best as you can. Have a great Tuesday. Be safe, be well, and be free.